Okay, so welcome to today's LinkedIn Live. I'm super excited about today's discussion. This is, of course, a Legally Speaking podcast, LinkedIn Live, sponsored by Clio, the world's leading legal tech platform transforming the legal experience for all. Let me start by asking you a super quick question. You've built your brand, you've grown your audience, you've even got revenue coming in, but do you actually own it? So, with that thought, today I'm delighted to be joined by the amazing Eamon and Cassine over at Riffer, and they sorted us out with our very own trademark fantastically well at the Legally Speaking podcast. So, really looking forward to today's discussion to talk all things intellectual property and to give you some strategies, tactics, things to be thinking about as you go on your journey as a creator or business or whatever it might be. So, a very warm welcome, firstly, Eamon and Cassine.
Hi there.
Hi, thanks for having us.
Most welcome. And Eamon, of course, I'm going to start with you because you're a returning guest to the Legally Speaking podcast. So I'd encourage folks to go and check out your full episode on the show. But let's start with the why then. Why is IP protection so critical for anyone actually building a brand, particularly in 2025?
Yeah, it's a really good question. And I suppose the sort of short answer is because probably at the point at which you're building the brand, it's the most valuable and it's the most important thing that you own. And I think when we think about intellectual property or intangible property, people very often forget that it is property. Most people, when they think of property, they think of physical property or real property. And everybody gets that buildings and machinery and stock are valuable things that can be bought and sold and rented and licensed. And, when things are valuable, we try to protect them. And with physical property, we try to protect them by putting them in warehouses and insuring them and stuff like that. You can't do that with IP, right? So if you have this really valuable thing to do with your business, which in the early days is your brand name, your brand identity, it's literally the thing that people use to find you. It's the thing they put into the domain bar. It's the thing they search on Google, all the rest of it. It's literally the center of the business. That's the sort of first thing. And the second thing I would say, which is a sort of a connected point, is the brand, and in particular the brand name, is the thing that, unlike almost everything else to do with your business, will endure forever, right? Your office can change. What your website looks like will change over time. Almost every product that you change will sort of rise and fall. You'll have some hero products, but all that stuff is sort of finite. Whereas the name is the thing that really, really sort of endures. And that's reflected in the way that IP law is structured. So trademarks, which protect brand names and brand assets and brand identifiers, last forever as long as you continue to use them and maintain them. Whereas things like patents, designs, even copyright, which lasts for a very long time, all of those things eventually expire and die and go into the sort of public domain. So that's what I would say. At the point at which you're starting your business, your brand is the really, really valuable, important thing you own. And it's going to last forever, so protect it early.
Yeah, and you're absolutely right, because I think because sometimes, like you say, you can pick up a T-shirt and it's got a logo on it and you see it, or it's something you wear or use. But when it's something perhaps like connected to, like for us, a podcast, it's virtual, it's something, there is so much value attachment to that. And as you go on your journey as well, not only so that's the start point, isn't it, when it gets to a trademark, because then you're building asset value around that, but getting that protection early on. So appreciate that. Okay, I want to talk about some of the myths, Cassine, because you hear a lot of things, you see a lot of things online, particularly a lot of fake news, shall we say. But what are some of the biggest IP myths you've come across from creators and founders and potentially even legal professionals?
Yeah, probably one of the biggest ones we see with trademarks is that they're universal. You've got one, therefore you have that protection everywhere. It's not quite the case. Trademarks are territorial. You have to basically go and collect them in each territory that you are providing goods and services in. And when we explain that to clients, sometimes they're a bit put out by that. Oh, I've got to buy lots of trademarks, or I've got to do lots of things in lots of countries. But the reality for most people is they start in one place, they build from there. You don't have to do it all at once. And yeah, it can get expensive if you want to go technically worldwide, but I would say there's very few brands that actually do end up purchasing trademarks all over the world. You tend to stick to what you actually need. Yes, that's the biggest one I see. Another issue I see is less of a myth, but more of a mistake I think people make, is that they don't really understand the differences between IP and where it actually lies in the business. So the difference between a trademark and how that can be helpful in comparison to copyright, or a contract that collects all of the IP together, and how that relationship works and looks after your IP in different ways. So yeah, they're the two biggest issues I see time and time again.
And that's why, from my own perspective as a creator, business owner, working with legal counsel who can talk you through that in a very simple, easy ways, which you guys have done for me, is so important. So you actually understand what you're doing as part of your journey, so you don't get caught up in these things. And you're right. I think, this is the world that we're in. Yeah, if you want to protect something valuable, then you do need to put in the work. Yes, you may start in your local jurisdiction, but if you really want to build something global or have something, look, we're all on the internet. Everything is global. You have the opportunity to reach everyone in the world, then it's worth over time in investing and putting in the work. Okay, Eamon, could you now talk us through 4 essential stages of a sort of trademark registration and what often catches people out, particularly when they try and DIY it?
Yeah, exactly. There's a lot of things. There's a lot of sort of pitfalls to watch out for. So the 4 stages, I guess, first are filing, examination, publication, and registration. Those are the 4 sort of main steps. I would say the first step is sort of the most important step, and probably the step at which the majority of the mistakes get made. So before you file the application, you want to make sure that you've done a bit of research to see whether what it is that you're trying to register is going to be registrable in the first place. And there are 2 principal aspects to that. The first is, are there any absolute reasons why your trademark application might be refused? They're called absolute grounds for refusal. The 2 main ones are, is it descriptive or is it otherwise non-distinctive? And the rationale is, the government can't give you a monopoly, a legal sort of exclusive right to use a descriptive word or phrase that everybody else needs to be able to use. So we couldn't get a trademark for, IP law firm, because clearly other people need to be able to use that. So that's the first thing. And you'd be surprised how often people sort of don't think about that or forget about that. And then they're sort of annoyed when their trademark gets objected to or refused later. The second thing that you need to think about is relative grounds for an objection, or relative grounds for refusal, as opposed to absolute. And that means, are there other rights out there that might form the basis of an opposition or a challenge to your application? The most obvious place to look for prior rights that might form the basis of an opposition is the Trademark Register. So if you're filing in the UK, you should search the UK Trademark Register. But I would always say do a little bit more recce than that, because it's possible for people to oppose your application on the basis of unregistered rights. And you won't always necessarily spot everything on the Trademark Register. So I would look at the word or logo that you're going to search for, and search for it in the Trademark Register, but look on Companies House, look on domain registers, look on social media platforms, look on news websites, do a bit of a Google, shake the trees and see if anything sort of pops out. So that's the stuff that you should try and sort of avoid getting wrong at the initial filing stage. The other thing is thinking about how you're going to use your trademark, and in particular, what goods and services are you going to be selling under that brand. And it's very, very common, as you said, when people sort of DIY it, to go and say, oh, I'm a clothing brand, I'm going to go and get protection in class 25 for clothing. Yay, everything's done. It was perfect. It was really cheap and easy. And then you say, right, but what if you sort of, well, firstly, if you're selling those clothes, it's not just class 25 you need, but you also need class 35, which is retail services in relation to those clothing, buying and selling those goods. Very, very commonly gets missed by people. But also think into the future. If you're selling clothing now, is that business going to expand in 3, 4, 5 years' time? Are you going to be selling bags? Are you going to be selling jewelry? Are you going to be selling sort of other things? So think about whether there's other things that you want to cover in the application. And the sort of third, I would say, big mistake that gets made at the filing stage is something I think Cassim slightly touched on, which is people sort of not thinking about the right rights for the right assets. And in this case, a slightly connected point is filing the wrong thing as a trademark. And it's very common for people to assume, if I've got 2 primary brand assets, primary brand identifiers, a word and a logo, think, Nike and the Nike swoosh. The quickest, easiest, cheapest way to get protection for those two things is to shove the two of them together into one logo mark and file the application. That's wrong. Almost always that's the wrong way to do that, because they're separate brand identifiers. They're going to be used separately by you, and they're potentially going to be infringed separately by infringers. So almost always you want to file a separate application for the word mark, which is usually the primary brand identifier, and then a second application for any secondary brand identifier, which may be a logo, which may be a slogan, it may be a product brand name as opposed to a headline brand name. So that's the other thing I would say, is that people sort of file for the wrong reasons. If you get all of that stuff right at the filing stage, then you go to the examination stage. Hopefully you don't get any refusals. No examiner is saying it's distinctive or descriptive, and that's all right. Then your application gets published. It goes to the opposition stage. Hopefully you don't get an opposition if you've sort of done your searches properly. And then you hit stage 4 and you get registration and your registration certificate. That's a very long-winded whistle-stop tour.
But it's important, isn't it? Because I think, if you're serious about building a brand, and particularly now with online and, various ways that you can take things, you need to do that due diligence from the start to avoid the headaches in the future. And I think there could be nothing worse in terms of, like you say, they give the example of retail. Well, you think you're covered for this, but actually you're then looking to try and do that, or, it may prohibit you, may cause issues. And yeah, I learned that point, actually. You mentioned about the different areas, because you look at lots of the big, huge corporations, they have different variations, don't they, in terms of what trademarks and of different are done. And it makes so much sense, particularly on the infringement side of things. When you see trying to little copycats or things coming in, they've really done their due diligence to ensure everything is protected within as much as they can. Kasim, from your experience dealing with a whole raft of different sectors and different brands, how do you think you should pick a brand name that's both sort of commercially savvy but also legally protectable?
So obviously, classic lawyer answer is the rules are the rules. Just look at the rules and make your decision based on that. From working with clients so much over the years, we do appreciate that clients will go, no, I like this name. I get that it doesn't fit the rules, but find me a way around it. So I would say maybe brainstorm your ideas first, be as creative as you can be. Then once you've got a list of names, assess them against the rules we've just talked through. So the main one being, is there anything out there that's similar at the moment? By a similar brand and then also look at, is it entirely descriptive? And when you're asking, is it entirely descriptive, you ask, is it describing what I'm actually providing, the goods, the services, the quality, so fine clothing, even if it's being what you think creative about that description, if it's still descriptive, then there's a chance. Then once you've assessed that, ask, okay, how much do I like this mark? Do I want to change it, or do I want to change it a bit? And I have quite a few clients who say, actually, we like that it's descriptive, because how else are people going to find us and what we do? So for those clients who are really sticking to their guns, we say, okay, try and add something distinctive to it, because the rule isn't you can't be descriptive, it's you can't be entirely descriptive. Try and change something at the start of the mark, add something distinctive. Lightning in front of anything is normally a distinctive word, something quite random. The other thing you can do is maybe go for a logo instead. If you kind of accept that this mark is not going to fit within the legal rules as easily, we can go for a logo and see if that adds some distinctiveness. And then that's really all there is to our assessment from the legal side. I'm sure there's lots of other brainstorming things you can do to come up with a creative, catchy name, but to get it to fit within the rules, you've got to assess it against the rules and then make a decision.
Yeah, no, and again, thank you for being so thorough on that. And Eamon, I probably want to bring it to our situation, really. I was quite excited when we came up with Legally Speaking podcast. We did a lot of due diligence way back in 2018. I think the amount of times we were searching Spotify, Apple for any episode that ever had any, we're really trying to ensure that, we were doing our homework. But so from our own trademark journey, obviously you guys have helped us in that process. Why do you think, maybe for other podcasters, I still think I'm still bullish on podcasting, even in the advent of AI, where AI will create podcasts, et cetera, et cetera, et cetera. Why do you think it's still a worthwhile process for people like perhaps myself, creators in this sort of space of podcasting and media, to go down this route?
Because, going back to the answer I gave at the very beginning, it's a worthwhile exercise for you in particular, for podcasters, for content creators, for influencers, for anyone who's doing anything online, and where all of your value resides in that sort of online intangible existence. This is your most valuable asset.
Yep.
So it is absolutely 100% an important exercise to do. And I mean, your story was interesting, Rob, because you already had Legally Speaking podcast established as a brand name. You know, you had lots of followers. It was sponsored by Clio. It was really, really popular. People really already sort of identified not just with those words, but with the visual
Yep.
red, black, and white combo. And so going back to Cassine's point about how, if there had been an issue with it, was it changeable? The commercial reality for you in this situation was it wasn't. We had to find a way to get it
Yep.
registered. And as we discussed, going back to sort of the middle of last year, we did have a little bit of a concern around descriptiveness or distinctiveness initially,
Yep.
because Legally Speaking podcast, it's a podcast, we're speaking about law stuff, maybe it's a bit descriptive. And in the 10 years or so that I've been doing this job, I've seen an increasing willingness on the part of trademark examiners to refuse, even if only sort of at the preliminary stage, trademark applications that were even slightly descriptive or non-distinctive. That has definitely, the instances of trademarks being refused for that reason has gone up. But I think we sort of thought about it, we analysed it, and we concluded that it probably was sufficiently distinctive on the basis that one of the things that gets looked at is the average man or woman on the street going to see this as a purely descriptive phrase or as purely non-distinctive, or are they going to understand that it's a designator of trade origin? And one of the things that can be an indicator of that distinctiveness is multiple meanings.
Yep.
So we're very lucky that you had very cleverly chosen something which was, it had two meanings. It was a sort of a pun, because obviously legally speaking is a commonly used phrase that means from the perspective of the law, but it also had this much more literal meaning. Legally speaking, we're speaking about the law. So that was one thing that we sort of factored into our analysis about how we were going to go and get it registered. The other was obviously the brand, the visual brand assets, the colors and the way the words sit together. And we had a discussion about word marks and logo marks, and the fact that you don't have a completely non-verbal logo. There was no sort of other element. So we were happy to go and get you your sort of stylized version of your word mark. And then obviously going back to what you just said about growing the business and thinking about the future, we looked at the various different classes or categories that might be relevant to you. And we sort of said, okay, we're planting our flag. This is our first filing in the UK. Maybe we look at other markets in future. Maybe we look at other goods and services. Maybe we look at other territories. But this is our core asset that, anyone who wants to buy your business would be interested in, anyone that wants to invest in your business would be interested in, and for anything you might want to do in terms of licensing or, co-branded projects that, you were sort of covered. So for anyone who's thinking about all those things, growth, investment, sale, how to sort of have other revenue streams for your brand, on things like merchandising, absolutely, this is a key thing to do as early as possible.
Because the worst thing you could do is build on quicksand. You could do all of the work, and then you actually find that someone's already got your trademark, or actually you can't get it trademarked. And I guess
Yeah.
we've talked. Christine, want to come to you. There's a whole raft of questions I would love to ask. And I know we've sort of only got a short amount of time today, but beyond, we've talked a lot about IP adding value. Let's talk about that then beyond the protection side of things. Potentially when you are pitching to investors or sponsors, Eamon was alluding to like licensing, but just talk us about, again, people are like, oh, still don't see the point. What is this IP value? So we've talked about it from a protection point of view, but let's talk about it actually in terms of that going a bit further on the IP value.
Yes, I think that the best example we can give that we see time and time again is with IP, you're really protecting the brand. So logos, identity, brand colors, name. And in practice, most people provide goods and services that are the same as your competitors. It's actually quite hard to have a USP. Sometimes you don't have a USP other than the fact that people know you for that brand and they really like that brand. Think of our favorite delivery services. There's certain ones that come and drop a parcel off and we're not happy about it. There's others who are better, but we just believe that. It might be true, but we mainly are led that way because we identify from the brand. So when someone comes to buy the brand later down the line, they want to see, okay, what am I actually buying? You're buying the reputation that comes with it, but it's all rooted in the marks. It's all rooted in the IP, the look and feel of the brand. So when people go to purchase, they will be paying more if they think that brand is better known, and that if they then take over the brand, it's secure. So it won't be pulled out from under their feet once they've taken over it. The other thing we see is when we talk about licensing, what we're really saying is you stay in charge of the brand, but you're letting other people use different bits of it. I was actually looking, my friend's a big fan of Hello Kitty and all those kinds of Asian cartoons and things like that. And she is obsessed at the moment with Labubus and all of that. And she bought some plates on the weekend, some paper plates that had Hello Kitty all over. And I then went on a tangent that nobody asked for about how Hello Kitty probably hasn't made those plates, but they've licensed the images to other people to use. And it will be a combination of trademarks, copyright. Same with Marvel characters, Disney. The reason you'll see it on Primark t-shirts is there's going to be licensing agreements in place. And those brands that own the IP at the top of the chain are making quite a lot of money without having to do too much. They've got an agreement in place, they own the brand, and they've sent someone else out there to further it. So yeah, you can make lots of money. It's a better income stream.
And, you know, we've got ideas about what we're thinking about here on the show as well from that licensing piece perspective, particularly when you go into events or you think about living or you think about other jurisdictions and guest hostings and things like that. There's quite a few different ways you can go with it, but also that kind of enhances your brand. But also, like you say, you own it and you're sort of reaping the rewards of what you've built and that reputation over time. Eamon, it's really important. You know, I recruit for lawyers day in, day out. I'm in the legal world day in, day out. I come across a whole raft of different lawyers, but how should someone choose the right IP lawyer and what red flags should they potentially look out for?
So just go to briffa.com. There are no red flags. Really straightforward. Pretty easy.
We'll move on.
No. It's a serious question. I mean, we're not right for everyone. Let's be honest about it. There are different law firms for, different fits for different people. And I would say that is the first thing that you need to identify is what do you want?
Yeah.
You know what I mean? If you want someone who's a real sort of IP expert, then go to an IP firm. Don't go to a general practice firm or a high street firm because you probably are going to be disappointed. You're going to end up either spending more because it's going to take that person longer to do the same job, or you're not going to get the outcome that you want. So that's the first thing. Identify what you want in terms of substance. And then, do your due diligence. We're all quite good at looking at things like reviews now because that's the way the whole world works. Look at Google reviews, look at Legal 500 if it's in the legal sector. Do a bit of research and say, does this person actually have the expertise for the job that I want to do? That's the substantive stuff. Then there's the sort of softer stuff. What are these people like? And in particular, my biggest test, even whenever I'm picking a dentist or a hairdresser or a bank or whatever, it's like, how well do they communicate? How responsive are they? Are they friendly? I think you learn so much from businesses and people about how they actually communicate with you. Are they happy to see you? Do they sort of respect that you're a customer? Do they respect that you're paying them money? And especially for us, this is a professional service and we are charging people hundreds and in some cases thousands of pounds to do it. We should absolutely respect their time. We should be on time. We should communicate well. And I think you mentioned earlier, Rob, about how this IP, legal stuff in general is complex. IP stuff can be particularly complex to people who don't know anything about it. Our job is to be translators. Yeah. It's not your job to go and read the Trademarks Act and understand what Section 5 says. It's my job to understand it sufficiently well that I can communicate it to you in plain English. If I can't do that, I haven't done my job properly. So those are the sort of first two things I would say. Make sure you've actually identified in a substantive sense what you want that person to do and make sure they have the expertise, and then look for, are you going to want to work with this person? Are they nice to work with? Are they reliable? Are they respectful of your time? Are they responsive? And I guess the red flag's the opposite of all of that. Yes. It's a red flag if the person has never filed a trademark application before, and it's a red flag if it's taking them 3 days to respond to an email.
Yeah.
they're not good communicators then.
No, all very valid points, and you touched on costs there, and I'm going to come to you on that, Cassim, next. But just sort of, I always talk a lot about when I do keynotes or speak to people. There's a lot of focus of ROI, but I think the COI is very important, which is the cost of inaction, the cost of not doing something that potentially could hamper you in the future. Because again, I think actually people not doubling down on utilizing AI tools once they've done their due diligence, doubling down on social, like doubling down on actually protecting whatever it is you're building is a real COI. And I think sometimes people see these as nice to have. Oh, it'll be nice to have a trademark. It'll be nice to do this. But I think the actual cost of inaction is potentially huge. So with that, though, it is a barrier for some people. People do look at things as just pure cost. So, and it is a concern maybe for startups or creators that are just trying to get out there that maybe haven't secured the big brand deals as of yet. So could you explain perhaps more why fixed fees make sense, especially for those startups or creators, Cassim? And, is that something you offer over at Briffa?
Yeah, it is. Most of our work is fixed fees as much as we can do it, and it's mainly because a lot of the work is relatively procedural, especially with trademarks, and we've done it so much that we know what's going to happen. We know most of the possible outcomes. But for those new businesses, especially, knowing that a law firm isn't going to turn the taps on is quite important, because you have so much resources, especially if you're starting. You've probably not made any money from the business yet, but you might have a pot of money aside. So what we tend to do is we try and give fixed fees, then break it down into phases. So at the start, here's the things you need to do now, here's the things you need to do later. But it's important for them for certainty and planning, because they certainly need it and they need to know that they can afford it. But sometimes you need to plan for it. You probably can't do everything at once. That would be a lot to ask. And even some of our biggest clients wouldn't come to us and order everything we possibly recommend at once. But yeah, at least they can plan for it. They'll have the fixed fees, and what you need to actually save up for.
Yeah. Quick question, Aidan. If you've DIY'd a trademark and been rejected, is it possible to go through? Is it possible to get that trademark through? And have you had experiences of that where people have tried to do it and actually thought, maybe I should get a lawyer to do this? And is there anything you would say to that? Because I know a lot of people that are still sort of getting that cost out of their head in terms of this is a value purchase. I think this is a valuable thing to do, and maybe they've gone through it and actually haven't got the result. Have you had any experiences of that, and any success stories or anything you would share?
Yeah, I mean, it can be salvageable. We definitely have had people who have come and filed an application, and it's either been, if it's refused on the grounds of distinctiveness or descriptiveness, that's harder to overcome. It's harder to sort of change the examiner's mind. If it's been opposed, that can be easier to solve, because either you can defend the opposition or you can try to negotiate some sort of coexistence terms. Very often people will oppose because they're annoyed about sort of a bit of what you're doing, but commercially they can get comfortable. But the sort of premise, the larger premise of your question is around, like, should people do this for cost reasons? It's almost always a false economy to do something yourself when you don't know what you're doing.
Yeah.
It is more likely than not that you're going to make a mistake. I could do my own dentistry. I could cut my own hair. I don't do those things. There's a reason for that, because the consequences of me trying to do something I don't know how to do are high. It's exactly the same here. I would say the more common outcome when somebody comes to us having had an objection or an opposition is that we end up having to refile the application, and the client ends up paying twice. It's like a dictionary definition of a false economy. You think you're going to do something yourself and save money, you end up paying on the double. So, I mean, going back to Cassim's point as well about fixed fees and planning, I think that's one of the things that we're sort of quite good at, is we meet businesses at the early stage, we map everything out, almost like a mini audit, and you give people a timeline and say, look, here are the sort of 10 things we think you need to do, but we can map this out over the course of a year or 18 months or 2 or even 3 years, and we can help you to do the priority list. And then you might spend a couple of £100 every quarter or every 6 months. And when you divide it down like that for people and they start to see it as an investment rather than a grudge purchase, then works then as a business strategy, as a business proposition.
Yeah, and that's the way I view things. Price is what you pay, but value is what you get. And I think the other key point is, you don't hire a lawyer to answer my questions. You hire a lawyer because they know the right questions to ask in the first place, right? And it's to your point about yes, you might be able to go into your mouth and start looking around, but you're probably not highly qualified, to maybe do a filling or something else. And it's so true, isn't it? And I think I use the simple analogy of you wouldn't necessarily go to your GP if you needed a heart operation. You would go to a specialist heart doctor that hopefully had done many, many things. And that's the way I think you need to look at it, particularly when it's sort of invisible type, professional services. You can't physically see maybe, the end result straight away. I think it's so, so valuable, particularly your IP and your assets, that you really do protect them, even now more than ever, particularly in the way of we can get into deep fakes, AI, and the whole things that's going on. There's a whole minefield out there. I think it really is the absolute non-negotiable base layer for any creator, anyone putting out content, anyone building a brand, to ensure that you look after yourself. And we've touched on it slightly, Kasim, but anything you would like to build on in terms of other assets, like maybe content, databases, and visuals? Can it all be protected beyond the brand name, or can it not?
Potentially. Really depends on what it is. And again, that's what a lawyer would help you with. It's hard for us to give black and white answers without seeing what we're assessing. But I tend to say to clients, look, write down who you've been working with and what's been made, and then we from there can tell you what it is from an IP perspective, and whether the ownership position, which is nearly always the first thing that needs sorting, needs to change. But yeah, things like databases, visuals, it will almost certainly be copyright. So it's normally contracts that will help move that. But yeah, with other assets, who knows? We'll have to look at it.
Yeah, case by case basis, and that, to the point, it's why you need to have these initial discussions. I mean, we've gone through a lot of content there in a short space of time. So maybe a sort of wrap up question to you, Eamon, to maybe reduce hopefully overwhelm for people. If someone's listening to this and they are a creator, or they have a business, or they have a brand, and they haven't taken any IP steps as of yet, what's maybe the very first thing they should think about doing or take action on doing now?
Well, Briffa.com.
Yeah.
Contact us. No, actually, the very last thing Cassine said is probably the first thing I would do is blank sheet of paper, identify everyone that you've worked with and everything that you have created of value. And the asset test for that is, would I be annoyed if someone else took it? Or would I be annoyed if someone else lost it? Because without getting too much into the weeds, there are registered and unregistered rights. So patents, trademarks, and registered design are these rights where you sort of very, very clearly define the parameters of what you want to protect, whether it's an invention or a product design or a trademark, and you go and send off an application to an IP office and it gets registered. Those rights tend to be more straightforward just because there's sort of certainty and precision about what you're trying to protect. The IP rights that tend to get lost are the unregistered IP rights. Copyright, unregistered designs, database rights, trade secrets. And it's because there are all these sort of default positions in the law. So I could commission you, Rob, if you're an artist, to do a piece of work for me. And even though I've paid for it, and even though I'm the commissioner, you're the author. So the law says that by default, unless you're my employee, you own the copyright in that. Similarly, if I disclose confidential information to you, but I don't have an NDA in place, or there's no other sort of circumstance of confidence, then that trade secret, that the proprietary value in that confidential information can be lost. So if you've done nothing, what Cassine just said is right. Identify all the stakeholders, identify all the works, and then contact Briffa or contact someone who can advise you. And we'll do what Cassine just said, which is we start to map out, okay, this is the valuable proprietary information, confidential information, trade secrets over there. We need to get NDAs. We need to get contracts in place to protect this. Here is all the stuff protectable by copyright and design rights, whether it's audiovisual content, literary content, whatever it might be, educational material, marketing material, whatever. That needs to be protectable, usually by a contract to secure its ownership. And then maybe there's some stuff over here that's registrable. The chief asset, registrable asset, would be the trademark. But you may also have product designs and inventions. And we sort of map all that out and try to put a plan in place to do that in a structured and cost efficient way, taking account of timelines. So novelty is relevant for some IP rights, but not for others. So sometimes there's a particular reason why we do things in particular orders. But yeah, that's a long-winded, slightly waffly way of saying get out a blank sheet of paper, identify all the valuable stuff, and then take legal advice from an IP solicitor or an IP advisor as early as possible. And don't disclose anything. So if you haven't yet disclosed anything, keep everything sort of confidential until you've taken advice.
Yeah, love that. And maybe just one quick final point for you, Cassim, because I think it leads nicely on. We've talked a lot about contracts, because I think it may come under sort of a bit of a myth, or people may not just be aware of it, in terms of, if you are a creator or a brand and you're instructing external people to create your visuals or do your content for you, is it worth just talking to that? Because again, I think there might be some assumptions that people think, and maybe why the importance of contracts or agreements is really worthwhile doing.
Yeah, it's critical. I mean, also to have it, even if someone puts a contract in front of you, but it's been drafted by their lawyers or by them, it needs at least checking. We see myths about this, like a contract can't be formed unless it's in writing. The reality is contracts can be formed in lots of ways, but when it comes to IP and actually owning IP, it really needs to be written down, because assignments, which is the posh way of saying transfer and ownership, it generally needs to be written down and in black and white. It also just helps you going forward to have that evidence of it. So have a contract in place. And then the other issue we see is that people will, we're seeing it a lot, ChatGPT contracts, or they've been presented with a contract and they think, well, the other side's helping me, why wouldn't they? Why wouldn't it help or be in my best interest? But contracts can be quite complicated, and the IP clauses sometimes aren't contingent on the termination clauses, when ideally you would have them contingent on each other. So you might think this contract, you can end it and you can take your IP back at the end of it, but it's not always the case, and the drafting is very tricky. So yeah, have them reviewed, have them drafted, and have your own representation.
Love it. Yep. And I think it was worth going through those extra pieces of detail. I've really enjoyed today's discussion. It's been really rich. So super grateful to you both, Eamon and Cassim, for your time today. If folks do want to know more about your services, or indeed get in touch if they're thinking about trademark, copyrights, all things IP, patents, etc., where do they need to go, Eamon?
For the third time, Rob. Briffa.com. We're plastered all over the internet. You'll find us on Facebook, Instagram, LinkedIn, or just Google Briffa. We'll pop up. We've got offices in London and Dublin, and we work with clients all over the world, particularly for trademark registrations, because, as Cassim said, they're sort of global. And anyone can get in touch to arrange a consultation or whatever is needed.
Fabulous. Well, look, hopefully folks have enjoyed today. If you have, please do drop us some messages. We may look to do some future episodes as well, as I think the world of IP is also fast changing, and I think it's always good to try and educate and bring value to our listeners. So just remember, a brand isn't just an idea, folks, it's an asset. So you've got to go out there and take the steps to actually protect it. And if you want to learn more, obviously feel free, as Eamon said, to go to briffa.com. And if you'd like to know more about Legally Speaking Podcast, feel free to go to legallyspeakingpodcast.com as well. We have lots of exciting things coming up for the rest of this year, so keep an eye out on our socials. But for now, thanks so much once again, Cassim and Eamon, for joining me today. Really enjoyed it. Over and out.